In California, where I practice, there is no right to inherit. There's no right for your spouse to inherit. There's no statutory right for your children to inherit. You can give all of your money to a charitable interest. You can give all of your money to Farmer Ed down the road. Hello, and thank you for joining me today. My name is Anita Steburg. I am the CEO and founder of Steburg Law Firm, which is a law firm in San Jose, California, where we help people with their tax issues, trust and probate administration, and probate and trust litigation. Today, I want to talk to you about, and this is coming from a litigator's perspective. When you talk to your estate planner about disinheriting, it's going to be a very different conversation than if you have it with me, who is a litigator, who I defend trust contests, I brought trust contests. There are certain things that you can or should consider before you decide to disinherit a child for whatever reason. Maybe they're bratty, maybe they are not good with money, maybe you don't like their spouse. There's a lot of reasons that people will disinherit a child, or maybe you just don't communicate with them and they haven't seen you, you haven't seen them in a number of years. And so the decision's made to write them out of the will or the trust, write them out of your estate plan. I'm going to give you some things to consider from a litigator's perspective that may reduce the possibility of a trust or will contest later on. Let's get to it. So if you are thinking about disinheriting a child, the first question that I would want you to consider is why? And I mean, like, really why? Not just, I don't know, it seems the right thing to do, it's fair to my other kids, really, but that's not the answer to the question. Why do you want to disinherit your child? If the answer is, and these are perfectly good answers, they're not in my life anymore. I haven't seen them and they have not attempted to contact me for 15 years. I don't like their spouse. They're not really good with money. They're just going to burn through it. There's a lot of different reasons. There's a lot of different ways to answer that. And whatever your reason is, it's perfectly valid. But what we don't want is for you to put in an estate plan that I want to disinherit this child, Brat X, and then have Brat X, after you pass away, now file a trust or a will contest. So what things can you do or should you do, or what things that you are considering? Now, if you are disinheriting them because you don't like their spouse, or you think their spouse is going to get their grubby hands on it, it's going to become community property, and then they're going to divorce your child, maybe there's some different things that you can do in the context of your estate plan, such as put it so that child does not get their distribution outright. Maybe it stays in trust, and the use of those funds are restricted to certain types of expenses. And there's a lot of different ways to do it. For example, if the reason that you want to disinherit, they are on public needs benefits, and you want to make sure that they're not going to get kicked off of those public needs benefits if they inherit. You can do a special needs trust. So if there are some specific concerns about money, or about them being on special benefits, or they're going to need special assistance, there's ways to handle that within the estate planning context. If the reason is, I do not want them to inherit, they told me 15 years ago that they wish me dead, and so I'm going to disinherit them when I do my estate plan, that's fine. That you can absolutely do. In California, where I practice, there is no right to inherit. There's no right for your spouse to inherit. There's no statutory right for your children to inherit. You can give all of your money to a charitable interest. You can give all of your money to Farmer Ed down the road. You can give it to whoever you want as long as you have sound mind. What we want to do, at least from a litigator's perspective, is decrease the possibility of a trust contest. So normally someone's disinherited, they do not receive anything. And if they contest the trust and they lose, guess what? They still don't receive anything. And you can't contest a trust just because you don't like it. The reasons that you can contest a trust, you generally have to put a reason to it. My parents lacked capacity when they signed it. They were being unduly influenced. This is not their signature. You have to have a hook or a reason to contest it. You can't just say, I don't like it. So when we talk about a trust contest, we're not talking about a child bringing forth a petition in court because they don't like it. They will have to allege something. If they didn't receive anything now, and if they do a trust contest and they lose, they don't receive anything, there's nothing to prevent them. There's no barrier to that. So from a litigator's perspective, what I have seen very successful is you give them a small portion of something, whatever that is. Maybe instead of them inheriting $100,000, because you have $300,000 and you have 3 children, each child will get approximately $100,000, is give them something less. Give them something that will cause them to pause and say, do I really want to contest this trust? Because if I lose, and if that trust has a no contest clause and I contest it and I lose, I'm going to give up this amount of money. And it depends on the assets that are in the trust. It depends on that child's standard of living. For some people, maybe 10,000 is enough. For others, maybe 30,000. But you don't need to give them the full 100,000. You can give them $30,000, and then the remaining 270,000 distributed between your other 2 kids. It will make it, in some cases, less likely that that child will contest the trust. Something else to consider, especially if you have a long-standing estate plan that did not disinherit that child, and for whatever reason, you change the trust and you die shortly thereafter, it makes it an easier argument to say it was because of somebody's undue influence. They have to allege who's undue influence, but it can be done. So something else that you can do is change it sooner rather than later. If you changed it 10 years ago and your capacity was fine 10 years ago, it's going to be harder to contest that trust. If you get a diagnosis of dementia, you wait a year, now you're questionable, it's very iffy if you have capacity, but you go ahead and change your estate plan, that's going to make a contest a little bit more likely. It's going to make it easier for that child who wasn't receiving anything to contest it. So from a litigator's perspective, I really like having a smaller gift in there to that child, plus having a no contest clause. However, let's just say that that is not what you want. You do not want that. And so you want to absolutely disinherit them. You want them to have nothing. Okay, put a no contest clause in there. In California, like I said, there's still ways to contest it. Additionally, assuming that you do not have a diagnosis or people around you have questioning, do you have the beginning stages of dementia? Change it sooner rather than later. If you're changing your estate plan and you have been diagnosed with dementia, but it's at the beginning stages, see a doctor just before you execute that the trust amendment or the trust changes that will disinherit or set up a new estate plan. Because when that child goes to contest the trust and says, my mom didn't have capacity, she already had dementia, first thing that's going to come up is the doctor's capacity evaluation and his or her analysis that says, no, they did have the necessary capacity to make those changes. It makes it harder for that child who you want to disinherit to win. So there's a lot of ways that you can work around it. And it's just being a little more smart, taking a little bit more effort. But once again, the law says you can disinherit whoever you want. There is no right to inherit under California law. So if you wanted to, you can absolutely leave nothing for your child. Your bratty child that, for whatever reason, you've decided this is the best course of action. I always prefer to give them a smaller gift, and that way they have something to lose. But you do not have to do that. That is just from a litigator's perspective. I hope that you enjoyed this. I hope that this is helpful. If you know of somebody who you would find this useful, please share this.